like to jump into the first segment now. Very pleased to have Andrea Barton Reeves, the CEO of the Connecticut Paid Leave Authority. And as I said a moment ago, this is a law that was enacted in 2019 by the state legislature. And there's been a long lead-up time for the logistics, education, things like that. And we're really in the focus of the education mode right now. And I know Andrea and her staff have been out doing a lot of these sessions, and we really appreciate their coming today to brief you on this important topic. Andrea was appointed by Governor Lamont this past January. I'm sure it seems like a longer period of time for her with the volume of work that she's taken on. Andrea previously served as president and CEO of HARC Incorporated, a not-for-profit organization in the Hartford area providing services for people with intellectual and other disabilities and their families. Cause near and dear to my heart as a former special ed teacher. I know that's a service area very much in need of expertise. Previously, Andrea also served as director for other programs, Lawyers for Children America, and worked in the insurance industry at Chubb. She's on a number of organizational and community boards, including she's been president of the Connecticut Bar Foundation, chaired the Village for Families and Children Services organization, Connecticut Community Nonprofit Alliance, YMCA Hartford Region, and Leadership Greater Hartford. Andrea was named Hartford Business Journal's 40 Under 40 and 5 New Leaders to Watch and 100 Women of Color Class of 2020. Really well-deserved and wonderful awards and recognition. And on a personal note, Andrea has a Bachelor of Arts degree from Rutgers University, my alma mater, and a law degree from New York Law School, also my alma mater. And she is a native from New Jersey. We won't hold that against her. I am also a native of New Jersey, and I ask you not to hold that against me. So I've heard Andrea speak on this topic before, and she's extremely knowledgeable and will be helpful. Again, I urge you to pose questions in the Q&A function as you think of them. I may hold off if I know it's something she's going to address in a few minutes. Otherwise, we'll try to catch as many as we can. Now I'll pass it over to Andrea. Welcome.
Thank you, Mark. Good morning. Thank you, everyone, for coming. I, too, would like to express my appreciation to CBIA for having us today. You have actually been a great partner in helping us spread the word about paid family and medical leave, and I appreciate the opportunity to be here today. I also would like to thank Kaden Escalera and Mikhail. When I was at HARC, they were actually the counsel that we retained to help us with our organized labor matters, and they were outstanding and also very generous in their support of us as a not-for-profit. So I want to thank Pat Mikhail in particular for his support. So let's get going, and we can talk about paid leave this morning. So as Mark mentioned, I'm Andrea Barton Reeves, and I'm the CEO of the Paid Leave Authority. We don't need that. We're good, Mark. Thank you. We can go to the next slide. Thank you. I appreciate the really warm welcome. So today we'll talk about paid leave, the qualifying reasons for leave, private plans, which I know a lot of employers have some interest in, the paid leave site itself and registering your business, some additional resources that are available on the site for you, and then we'll launch into our questions and answers. Okay, so a bit about the Paid Leave Authority. We have two primary missions. The first is really to provide some form of wage replacement for our Connecticut families and our Connecticut workforce, so they don't have to worry about lost income when they need to take time off to care for themselves or their families. So we do that. Even though the slide says employees, it really should read that it's for Connecticut's workforce for us to provide pathways for accessible paid family leave benefits, and to help employers and administrators and healthcare providers by really teaching them about the law and supporting them as they're implementing it through their workplaces and the people that they support. Next slide, please. We have 5 primary responsibilities at the Paid Leave Authority. The first is outreach and engagement, really teaching people about paid leave, how it works, what their relative responsibilities are, and what the benefits will be. know, Mark, that you mentioned that there's a long on-ramp. It's actually extraordinarily short, considering I started in March in a pandemic, and we have to start providing support for contributions in January. There's not a lot of sleep that's happening at the Paid Leave Authority. We are also responsible for developing the policies and procedures, establishing the employee, actually the contribution rate, not just for employees, because sole proprietors and self-employed people can also participate. We audit and improve private plans, and we also administer claims for paid leave benefits. Here are some key dates that you should know about and keep in mind. First, we launched our website on September 4th, and you can find that at ctpaidleave.org. And there you will really find a plethora of information on paid leave. There are also documents that you can download on the employer site near the bottom of the page, where you'll find a toolkit, a paycheck stuffer, every kind of guide that you might need to inform your employees about this upcoming contribution and benefit. Registration begins on November 23rd. It's actually open now if you're interested in going in, but the wider registration process begins on the 23rd. January 1st, employers begin deducting 0.5% of wages to contribute to the Paid Leave Trust Fund. If you're a sole proprietor or self-employed, you may also make contributions to the fund. If you choose to participate, though, you have to remain in for 3 years. And then benefits will become available in January of 2022. So what are some of the reasons that you can qualify for paid leave? They include these: to create or expand your family through the birth of a child, through placement of a child with your family through adoption or foster care, for your own serious health condition or that of a family member, to serve as an organ or bone marrow donor, and if you are expecting a child by pregnancy, depending on what your doctor, your healthcare provider says, you may be entitled to up to 14 weeks of leave for incapacitation during your pregnancy. There's also special leave that's available for families of those who are active in the military who are injured, and there's qualifying as exigency leave for those that are being deployed. And finally, there's up to 12 days of leave that are available that are paid for those who are impacted by family violence. Who's covered by this law? There are generally two categories of people who are covered and those who are not. Those who are covered are employees who work for an employer who employs one or more people. As I mentioned earlier, the sole proprietors and those who are self-employed have the option of participating in the plan and can enroll at any time. But if they do, they must remain in for 3 years. Generally, who's not covered are employees of the state of Connecticut, municipalities, non-public elementary and secondary schools, and local and regional boards of education. So what I'll say here with respect to the exceptions is this: if you work for the state of Connecticut, a municipality, or a local or regional board of education, or if any of your clients do, and there is a bargaining unit within any of those entities, and that bargaining unit bargains for inclusion in the plan, then they then may participate in the plan. But what you should know is if the bargaining unit chooses to participate in the plan, then the entire workforce, whether organized by labor or not, will then also participate in the plan. The only workforce to which that is an exception is the non-public elementary or secondary schools, which cannot participate under any circumstances. Next slide, please. So here's a summary of some of the eligibility and the leave and the length of the paid leave benefits. In order to get paid leave benefits from the Paid Leave Authority, you have to have worked and earned at least $2,325 in the highest earning quarter of the last 4 of the 5 quarters. And an employee can earn that from multiple employers. You either have had to have currently been employed and working in Connecticut or have worked within the last 12 weeks. And the length of leave to which a person may be eligible is up to 12 weeks in a 12-month period, with the exception of military caregiver leave. That leave can be as long as 26 weeks, but only 12 of those weeks are paid. There's also available up to 12 days per calendar year for family violence leave, and as I mentioned earlier, there's an additional 2 weeks of leave due for incapacitation during pregnancy. There is a reason that I emphasize the during pregnancy rather than due to, because the statutory language is very clear that incapacitation has to be occurring during the pregnancy. Next slide, please. So as employers are determining whether a person is eligible for any kind of family or medical leave qualifying event, as they come in your door to your HR director or to your third-party administrator, whoever handles those issues for you, there should be two questions that are asked in the context of determining eligibility for leave. The first is whether or not that employee is eligible for job protected leave under not just this statute, but perhaps others, one or more statutes. And if so, whether or not they're qualified for income replacement while they are on leave. We urge employers to ask both of these questions when they're determining the type of leave a person may be eligible for and whether or not they qualify for income replacement while on that leave. Next slide, please. Eligibility for job protected leave can be found in a number of different categories. I've
Andrea?
just lost my slide.
Yeah.
Yeah.
I just want to interject one or two quick questions.
Okay.
Serious health conditions includes mental health ailments, I assume,
Absolutely.
similar to
Absolutely.
FMLA.
Yes.
The point you made on pregnancy, so then an employee who's incapacitated as a result of pregnancy, possibly outside, being after childbirth, postpartum depression or other complications, that would clearly still be a qualifying FMLA leave, but would not qualify for paid leave under the Connecticut this law that we're talking about.
It may not, and so we're still trying to determine that in partnership with the Department of Labor. That language of during versus due to is different than what's in the current FMLA. So that's why we're partnering with the Department of Labor to see if we can get some flexibility in how that language is applied. Because we raised the very same circumstance that you just did, which is women suffer from postpartum depression. Is that not something that you can get paid leave for and be able to recover from?
On the other hand, if a doctor were to certify that the woman is incapacitated due to a serious health condition, whether it's related to pregnancy or not, that's a broader definition that could be a landing place to be eligible for that benefit.
It's absolutely correct.
Okay. Thank you.
You're welcome. All right. So an employee may be eligible for federal FMLA only or state FMLA only, or both running concurrently. Neither, but may have job protection as a reasonable accommodation, for example, under the Americans with Disabilities Act, or they may not have any job protected leave at all. And that's why we ask employers to engage in a broad analysis and not just narrow it to whether or not their leave is paid or not. Next slide, please. Under the changed Family and Medical Leave Act, which will become effective in our state in January 1 of 2022, here are the new rules. The employer now will be covered under this law if they have one or more employees. And that's different than how the law exists now, where an employer is only covered if they have 75 employees or more. The employee has had to have worked for the employer for at least 3 months to have had job protected leave. Currently, the law says that that employee would have had to work for at least a year and a certain number of hours. The reason for the leave has to be covered by the state FMLA, and those reasons I outlined earlier. And they would then be eligible if they had not already used all of their entitlement, which would then be a 12-week period of time and a 12-month period with the 2 additional weeks for the pregnancy disability. There should also be a question asked as to whether or not that employee is eligible for other job protected leave, as I mentioned, under the ADA, SFIPA, and the Pregnancy Disability Act. Next slide. Of course, there are other kinds of job protected leave, and we know that with respect to federal leave, and that is usually covered if you employ, it's usually applicable to you as an employer if you have 50 or more employees. We do know that there's an hours worked requirement under federal leave of 1,250 hours in the 12 months immediately preceding the leave. That leave also has to be covered by FMLA, and the person has had not to have used all of their time. Again, we ask if you apply the analysis to see whether or not the person has other job protected leave, and what's particularly important here, and this is statutory, is that no matter whether or not they're covered by any other job protected leave, if they are collecting workers' compensation benefits, they cannot do that under this new law and also receive benefits for paid leave from the Paid Leave Authority. Next slide. So here's some important things we think that employers just need to know in a nutshell. That from the employer's perspective, you will notify the employees to whether or not they qualify for leave. Go ahead, Mark. Now I know that it's not my connection; it's you coming back in. I was so
Um,
confused the first time. It's
I'm sorry.
okay.
I'm sorry. I
No, it's
just want
okay.
to I just want to ask you to emphasize the point because I think this is a real sort of earth-shattering change for some employers. Those smaller employers
It's
that have never
significant.
had to worry about FMLA now will. And
Yes, they will.
the frustration that so many employers have had with 16 weeks and a 24-month period, 12 weeks and a 12-month period, that's going to go away
Yeah,
because the Connecticut law,
that will go away.
January 22, is going to be shrunk to 12 weeks in a 12-month period, consistent with the federal law. Is that correct?
That's correct.
Okay.
That is correct. I think the other thing that's important to know, though, is that that 1 year period in which employees had to work in order to get job protection, that is now only 3 months. So that's going to be
Okay.
significantly different, and it won't parallel the federal law. So that's another complication that larger employers who may have been accustomed to federal leave will now have to reconcile.
Okay. So a bit more generous entitlement waiting period for
Yes.
in favor of the employee. Okay, all right. I just wanted to
Yes.
emphasize that because I think sometimes people miss that, and then the question comes up later. So, but sorry for
Yeah.
the
No. Agreed.
interruptions.
No.
Okay,
No. It's fine. It's fine. I appreciate the questions. All right. So now, especially Mark makes an excellent point for smaller employers. This is an entirely new world. So if you have any questions at all, there's a support email that you can send, and I'll review that at the end of this presentation, or I'll share with you how you can send all the questions that you have. We will also be holding webinars for small employers as well, and we're hoping to do that. We're doing it hopefully in partnership with the Small Business Administration, and hopefully the CBIA will allow us to do this as well, so we can walk you through those laws because they can be rather complex. So the next point we need to know is that the employer will notify the employee whether or not they can use some of their already accrued time to cover some of their time off. But remember, under this new law, an employee is entitled to keep up to 2 weeks of their accrued time. So while this law doesn't really ask you to make significant changes, or it doesn't require you to make any changes, quite frankly, to your policies, with the exception of this. So if your policy now requires your employees to use up all of their accrued time for their FMLA, under the state law, you will not be able to do that anymore come 2022. So you can then, if your employee qualifies for leave, you can let them, but they don't have enough accrued time to cover all of it. You can then let them know that they can come to the paid leave authority to receive some form of wage replacement for the remainder of the time that isn't covered by any paid time they may have from you. So that doesn't mean that, so the eligibility to receive benefits from the paid leave authority is not equivalent to job protected leave. And so we make this point all the time, and we will continue to make it to the employee community that we will speak to. You may be able to get your leave paid, but you really should make sure that you have a job to come back to. So communication with your employer is really critical. If you, in fact, have a private plan, then the employer, usually through its third-party administrator, will be managing the qualification for leave and the paid leave itself. That will not be something that the authority would do. Okay, next slide, please. So with respect to income replacement, an employee can receive their paid leave benefits from the paid leave authority concurrently with any other employer-provided income replacement, as long as it doesn't equal more than 100% of the employee's regular wages. So in one of our webinars, we had this really interesting question. Well, what if the employee has purchased their own disability policy, like AFLAC as an example, for wage replacement? That would not be, that's their own policy. If they want to receive other benefits from that, then that's certainly something that they've arranged on their own. What we're looking for is benefits coordination with the employer, and we will be in communication with the employer. So an employer under the statute in 2022, they can require an employee to use their paid time off, or they can make it an option. But as I mentioned before, they have to let them keep up to 2 weeks of their time. So generally, short-term and long-term disabilities policies don't meet the qualifications for a private plan under the statute, but they can be used as part of income replacement or wage replacement for employees. Generally, those policies have a provision that requires that state-provided paid benefits be used first before those policies kick in and provide any benefits. So even under those circumstances, you can send your employees to the Paid Leave Authority, and we'll work with you or your HR team to work on benefits administration and coordination. Next slide, please. Actually, we can go to the next slide because I've already covered this. Thank you. Another question that comes up are spouses who work for the same employer. Under the federal FMLA, which will not change, spouses are required to share their 12-week job protected leave if the reason for the leave is to bond with a newborn or a child that's new and placed with your family, or to care for a parent with a serious health condition. And as under the current state FMLA, those same rules apply. But under the new FMLA that will come into effect in 2022, spouses will not be required to share their 12-week leave under any circumstances and for any reason. So that too, Mark, I think is a new change that employers will have to become accustomed to and reconcile with federal leave. Next slide, please. Okay. So a bit about private plans. The statute, as you all know, provides for the option for employers to provide a private plan in lieu of participating in the state's public plan. But there are, of course, some caveats around that. The first is that the private plan has to offer the same or better benefits as the public plan, meaning that it has to offer the same reasons for leave. And in addition to that, it cannot cost the employees any more than it would cost to participate in the public plan, and that's 1/2 of 1% of wages as a contribution. You also have to have the ability to administer the claims and the benefits. And if that's something that you do yourself, or if that's something that you hire a third-party administrator to do, that's fine. The statute also requires that a vote be held so that the employees can approve the private plan option, and that vote must be of the majority of all of the eligible employees who work in the state of Connecticut. Even if you're a multi-state employer, it only includes those employees who work in the state. And then we at the Paid Leave Authority must approve the plan. We do get a lot of questions about, well, what does approval look like? Here's what it looks like. If you meet the criteria of the private plan within the statute, and you upload 3 pieces of information that allow us to make that determination, then we can approve your plan. Approval for the plan is a 3-year approval. We will essentially check in with you year over year to see if there's any change that's significant. Other than that, we're looking for 3-year approval timelines. So how does this work? Starting on November 23rd, you can go in and register with the Paid Leave Authority and let us know of your intent to engage in a private plan. There are, I think at this point, 8 or 9 insurers that have expressed an interest and have actually filed a declaration of insurance with Connecticut's insurance department, indicating that they will want to offer a private plan in the marketplace. So from one of those insurers, you can then approve a declaration. You can then obtain a declaration document, and also offer your employees something called a plain language guide. So that is essentially a template that we at the authority have created that summarizes what paid leave is. And it acts as a template that you as an employer, essentially your insurer, will help you create, that you can share with your employees so that you don't have to summarize the entire statute yourself, which is not an expectation we would have of anyone. So when you give your employees the declarations page saying, I have insurance, and the plain language guide, then you will hold your vote. And after you hold your vote and you have your majority or whatever the outcome might be, then we will then ask you to come back to the Paid Leave Authority website and do 3 things. You'll show us your proof of your vote, your 50% plus 1. You'll upload a copy of your declarations page, and you'll upload a copy of the plain language guide that you gave to your employees as a proof of an explanation of the plan that's being provided. So the statute is about 48 pages long. The plain language guide is probably about 5. And it probably answers a lot of the questions that your employees will have. Next slide, please. If you choose to offer a private plan through a self-insured plan, the process is essentially the same, but it has a couple of differences. You do have to get a self-insurance declaration document, which is not found on, it's found on the CT Paid Leave site and on the Department of Administrative Services site. Then you'll do the same thing. You will have your plain language guide, you'll have
lost the audio there for a second. We'll jump back to that, but I'm going to pose a question to, well, first some of the questions. One of the questions we've got is eligibility based on the calendar year of January to December or rolling year. My understanding is they'll offer the same options, and I'm going to answer this question and then ask Andrea to either confirm it or challenge it. But offering the same options available under FMLA, classic FMLA, calendar year, or some other fiscal year designated by the company. Another question is, would an employee be able to use the 12 weeks of leave under the Connecticut paid law and then take an additional leave under short-term disability? I would say if it's an employer-provided short-term disability plan, as Andrea noted earlier, there will be some coordination if it's the employer-provided plan, but if it's an AFLAC type plan, they could then seek the benefits there. Andrea, I think we're back again. Sorry, we lost the sound there for a moment. One of the questions I was answering in this brief interlude was,
Okay.
is eligibility based on the calendar year, or is it going to allow the selection of the 12-month period similar to what the federal and state FMLA allows?
Yeah, so it allows, right now the statute isn't specific as to what that period will be. I can tell you at the authority, we're going to use the rolling year because we think it's a better way of counting and it helps to avoid stacking
Okay,
of
all right.
benefits.
So
Yeah.
it will direct employers to administer this under that rolling calendar year, which is 12 months
Yeah.
as of the first use of leave, and then
Yeah. So
looking forward.
we can't dictate that to employers. We're going to strongly, strongly recommend that you use the rolling year.
Okay,
We
okay.
really are.
So
Because we know some have already made a deep investment in the calendar year. We know that. They've said that to us. We appreciate that. So we're not going to dictate that, and we don't have the authority to do that under the statute. We're just telling you that at the authority, we're going to be using rolling year.
okay, all right. And I'm gonna try to. There are some other questions we'll get to towards the end, but to stay with what you've been talking about, the private plan, just very quickly, why would an employer opt to administer a private plan rather than participate in the state's plan?
Yeah. So what some of the employers have said to us is that they'd rather have consistency in the benefits that are offered to their employees, and they'd rather have a better benefits coordination without sending their employees to another agency, especially for paid leave benefits. So that's the primary reason. Some employers have also said that they have fairly good sized organized labor, excuse me, sections or uh, constituencies within their workplaces. And so rather than, and some of them are different unions within the same workplace. So under those circumstances, they'd rather not manage all of that individually and then have a state authority as a part of that. They'd rather manage all of that internally. Those are two of the primary reasons that employers have told us that they prefer to have a private plan. And some of them would just like to just outsource all of their leave management to one organization, and that they would like to do that under a private plan as well.
So sounds like more an option that might be elected by a larger employer with the
That's true.
internal structural resources to handle that.
That's
Okay.
correct.
Okay, thanks.
Yes.
We'll get to some of the other questions as we move along, but I want to stay with your
Sure.
with your slides
Okay.
here. So if we can jump back to the
That's
slides.
great. Okay. All right. So as I was mentioning, if you have a self-insured plan, the difference between that and getting a plan from a private insurer, so to speak, or traditional insurer, is that you have to get your surety bond. You'll still use the same plain language guide, and you still have to have the same proof of majority vote. And then you will upload those documents, including your declarations document, onto our website. We will be doing the review and then approving your private plan. And again, that approval is for 3 years. Next slide, please. Okay, so we can go to the next slide. I've been talking a bit about registering and about the website. The website launched on September 4th, 2020. If you go to the employer portion of the website, you will find a number of documents that are available there for you. There are videos, There are downloadable guides, and I think mostly of note is that there is an employer toolkit that summarizes everything I've talked about today in one document. And there's also what we call a paycheck stuffer that you can download and send to your employees by email that says something along the lines of your paycheck's going to look a little different in January, and here's why. And then it directs them to a contribution calculator that is on the site on both the sole proprietor page and the employee page, where they can put in their wages and estimate what their contributions will be. So I really encourage everyone to go to that site and to send their employees there as well. I think we've done a lot of the heavy lifting for you. And if you're still having issues with that, you can contact us at the Paid Leave Authority. We'll be happy to walk you through that. Next slide, please. So a brief summary of the timeline. November 23rd is when large open registration begins, but as I've mentioned, it's open now if you'd like to do that. Payments, meaning the remittances of the contributions, are due the last day of the month following the end of the quarter. Applications for benefits, we hope will start in the fall or the winter of 2021, so about a year from now, because benefits should be made available according to the statute in January 1 of 2022. Next slide, please. So you've heard me talk a bit about registration. That's really just a way for you to let us know, hey, we're here and we're participating, and we will be remitting contributions to the fund on behalf of our employees. You do that by starting out by creating an account on what we call Business One Stop, which is business.ct.gov. Once you get your credentials there, we can go to the next slide, please. You then will be returned to the CT Paid Leave site, where you will register in 4 simple steps. I know it's hard to see this screen, so I'll just describe it. You're just going to enter your basic contact information and some very basic information about the type of business you are and your size. Next slide. The next one is a bit more information, your NAICS code, about how many people work at your organization and who your contact should be. Next slide. There's additional business information here, meaning other people that you'd also like to be able to enter or make changes to data on your behalf. You can do that there. Please, next slide. Yes, next slide. And you can also add more additional users here. So that's kind of on both screens. And then that's the last step. And then when we go to the next slide, you will be all set and you'll get a confirmation and registration number. So because we're in a soft launch of the registration, we've had about 350, 375 employers register so far. And the feedback that they've given us is that this is in fact a very easy process. So if you want to give it a try, please do. If you have questions, you can email us at support@ctpayleave.org, and someone will get back to you within 48 hours to help you with the registration process. Next slide, please. Okay, next slide. There are some additional resources, as I spoke of earlier. They include what we're calling an employee rights poster, which is a one-page summary of all the things your employees need to know. These are all downloadable from the employer page on the site. There is what we call a rack card, which is, again, an even smaller version of the poster. If we were in workplaces, these are things you would hand out or post, but instead you can email them. On the bottom of the page below that employer toolkit, which is the comprehensive summary of everything I've spoken of today, is that paycheck stuffer, as we call it. Of course, most people are paid electronically, but it's something that you can download and just send to your employees. And it does say on January 1, 2021, you will notice a change in your paycheck. And then there's always an employee fact sheet and an employer fact sheet that you can download as well. So all of these tools are available on the site, and they're downloadable and shareable. Next slide. Okay. And we're here for you. So on the website, there is a contact us portal. You can, if what you need, I haven't answered today, or if it's not in the frequently asked questions, you need to go to the contact us portal on the website, or you can email us directly at support@ctpayleave.org, and we will get back to you and help you. So thank you very much for your time. I appreciate it. So Mark, let's start answering some questions.
Yes, and I want to say also, I forgot to mention in my introduction that I'm a proud member of Connecticut SHRM on the State Council, and the Paid Leave Authority has reached out to SHRM and is doing some presentations for some of the chapters. I'm not going to say the dates because I'll mess them up. I'm not sure what they are, but if you go to CT SHRM and drill down into some of the individual chapters. I know HRACC has a presentation scheduled in the coming weeks, as does the State Council. And so I always also like to make a pitch for SHRM membership. So if I know we've got a really good turnout today, a lot of familiar names, and I won't say faces because I can't see them. But if you're not a member of one of the SHRM chapters in Connecticut, you're missing the boat. You really should be participating in those meetings, and they're all still conducting meetings virtually during this time. So that's another great resource that the Paid Leave Authority is collaborating with to get the word out and educate folks.
Mark, if I could just interrupt. Mark,
Yes.
if I could just interrupt for one moment. We at the Paid Leave Authority are also hosting a series of webinars as well. And they're in the morning, they're in lunchtime, they're in the afternoon, and they cover 4 areas: the legal implications, understanding paid leave, registration, and private plans. So those will be going out primarily in the Hartford Business Journal, and you should keep an eye out for those as well, because we really want people to be educated and get comfortable.
Great. You know, I think repetition sometimes helps to absorb
It
all
absolutely
of this
does.
stuff here.
It
So,
sure does.
couple of questions. Is there a penalty for not participating? If an employer ignores this process completely, says, hey, I've got a rich benefits package, I don't want to mess with this stuff.
Yeah, so we do have the authority under the statute to impose penalties. That's not really the approach we're taking in the first year. We understand that there are employers that are vehemently opposed to this in not just in theory, but philosophically. So we really want to work with them to say, we understand that, but you do need to participate. And if after some attempts for participation fail, then I think we'll take another step, but it's not the first place that we're going.
Okay. And I would say that for the employer that defers to the state to administer the program, it's just a payroll deduction and then letting the state handle it, similar to unemployment programs, workers' comp, et cetera. So it's really minimal involvement by the employer in that respect.
It is, but I don't want to minimize the impact on small employers who've not done this before. So it's not going to feel like it's just a switch for them, and I want to be really sensitive to that. And they may be the ones that just kind of throw their hands up and go, I'm not going to do this because I don't even get it. And we will be there to help you. We will.
Okay, and to make a plug from another perspective, it's job security for the HR profession. There's yet another task they need. Their employers will need them to take on. It's small state, Connecticut. We've got a lot of individuals working at Connecticut companies that reside in Massachusetts, Rhode Island, New York, even possibly New Jersey in some cases, coming into Connecticut to work. And then the other scenario is Connecticut companies that employ people who reside outside of Connecticut and work outside of Connecticut, but are employed by a Connecticut company. Can you speak to the responsibility in those two scenarios?
I can. The general rule that we're giving employers is that if you have an unemployment obligation to an employee that works in the state, then that employee then has a contribution obligation to the trust fund, but they also have the opportunity to be eligible for benefits. If you're a Connecticut-based company, but all of your people work in another state, then you don't have any employees that are here in the state as they're defined by the statute, and therefore those employees don't have an obligation to make a contribution or but they will also not be eligible for paid leave benefits. If they are having to work in Massachusetts, we know that that's a state that has paid leave, so they may be eligible there. But I know it can be confusing, but essentially it's if you're a Connecticut worker and you're employed by a Connecticut company and you work here. The other question that comes up, well, I'm not physically working there right now because of the pandemic, and I'm at home and other people are at home. So if I normally come into Connecticut and I work and I'm not physically there now, the Department of Labor has not changed the rules as we sit here today. And they've still said if you would have normally come into work in Connecticut, you're still considered a Connecticut employee and you would have an obligation to contribute, but then you'd also be eligible for benefits.
Okay, so it essentially follows the unemployment registration for the individual employee.
It does generally, yes.
So, all right, and I know I believe Massachusetts follows a similar rule for their paid leave program. So
That's correct.
employers that are unsure about certain workers might check with their payroll service to determine where the payroll taxes are being sent for that particular employee.
Correct.
Okay.
That would be the right approach.
All right, just lost my train of thought there.
Okay.
The registration for a business in Connecticut, that's different from Labor Department or Department of Revenue Services tax ID numbers. Is that correct?
No, it's not. So I want to make sure I understand the question. So we're asking employers to register. We do have in the process right now pending some agreements with the Department of Labor and the Department of Revenue Services to hopefully share some of their information. But there are some federal rules that limit that sharing of information with other quasi-governmental state agencies. So we're working through that. And while we do, we are asking employers to register directly. But you're going to be registering using your FEIN number. You're not. There's no other special number that you need. The registration number that you get at the end of that process is an internal number that you might give to us if you have a question about something that you put in your registration, or if we have a question. But it's not like a whole new number that you need for any purpose. We're trying not to have people do a whole new thing, because we know that that can be frustrating.
Okay. And can you speak to the steps an employer should follow to coordinate things with their payroll service? If they have an outside payroll service, is the employer registering, then the payroll service is simply the administrator of the remittances, or does the payroll service register independently?
So the answer to that is the typical lawyer answer, and that both are true. So we're asking the employer to register just so we know you're there, because eventually we do hope we'll get the information that we need from the Department of Labor, and that will help us to do some reconciliation. So we make sure that all employers who should be registered are. Your third-party administrator, your payroll provider, especially those large ones, should already know about this. We have been working with them since April. So the ADPs and the Paychecks of the world, they are very familiar with what's happening. They will then register as a third-party administrator, letting us know that they will be remitting your contributions from your employees on your behalf. So the reason we ask employers to register is this. Let's say it's a large one, they may be submitting a list of 50 employers for whom they will be submitting remittances on their behalf. But you should be on that list and you're not. The only way that we can make that match or figure out that miss is if you register and you tell us, I use ADP, but when we look at ADP, they're not on your list. So they may not be making the contributions on your behalf because they've missed adding you. That's why we want employers to know, because we don't want you to have the liability because your TPA missed something. So it's really, we're doing it for employer protection, essentially.
Okay.
So sorry.
Go ahead.
So some employers have said, well, I just want the TPA to do both for me. I want them to register for me and say that they're my TPA, and I want them to register themselves and be among the 50 that they provide services for. And that's fine. You need to tell your TPA that's what you want them to do so that you don't have to have the responsibility of registering. And some have agreed to do that, but that's been on an employer by employer basis.
Okay. And I will say, having spent some time on your website, you've done an excellent job with it. It's user-friendly, attractive, it's comfortable to go through, and there are specific links for third-party administrators for information for them as well. So you're really coming into it from the various participants' perspective. Unionized workforce, do they have to negotiate this in their collective bargaining agreement, or are they automatically going to be included with a payroll deduction and then a new benefit for members of the bargaining unit, whether they've bargained for that or not?
It's really the latter. So the statute reads that employees shall, and I think that was specifically done so that there is no bargaining about whether you're going to participate or not. The bargain, except for the municipalities and the local and regional boards of education, those are different, and the state, as I mentioned earlier. But if you're a private employer with a union in your shop, they will participate. The question is whether it's the public plan or the private plan. That's
Okay.
really the question.
Okay. One question with respect to timing, because benefits won't start to be paid to employees until January of 2022. Will they be able
Mhm.
to submit for paid leave for periods prior to that? So say
So,
November,
mhm.
December of 2021, someone is out for a qualifying leave under FMLA. Will that be eligible for coverage?
It will be eligible for coverage under the law that exists at the time. So they won't be able to apply for paid leave in 2022, and because benefits won't be available until 2022 for paid leave. There are some exceptions to that though, because we know that we'll start to get applications at the end of the year for benefits that will trigger in the beginning of the year, and that's particularly for bonding. So if a child is born in 2021, bonding is available for a year after the child is born. So we may receive applications, and employers may receive applications for bonding benefits that will be paid going into 2022, and that would be one of the things that people might apply for. We are expecting to receive applications early, before 2022, because benefits are to be paid statutorily by then. And our colleagues in other states have also strongly advised us to be prepared to take applications before benefits begin, because that has not turned out well for them in other states. So we're happy to take their advice on that.
Okay, so that raises two questions. One, similar to classic FMLA, an employee who has not been employed yet for a year goes out on a circumstance that otherwise would be qualifying, remains out through their anniversary date, and they're still employed, so they satisfy
Mhm.
the length of service requirement. So what you're describing is consistent with that. They could age into, so to speak, because the law will begin to take effect after the 1st of 2022. And
Yes, so
if they're
it's
continuing in a capacity, that would be a qualifying situation that would then become covered.
Well, not exactly. So it's tough because employers, if a person takes leave, let's say in June of 2021, they're still covered by the law as it currently exists. And it doesn't then they don't then switch over. They have a tail to that. So the law that existed will continue to apply to them. If they are taking their leave in 2022, then the new law applies to them. So it isn't retroactive, and it also doesn't sort of change in the middle of leave. And I know this is going to be some confusing and a little frustrating for people who feel that I took my leave in November of 2021, it goes through April of 2022. Don't I get the benefit of paid leave? The answer is no, because your leave actually started in November, so the old law applies to you.
Okay. And
Yeah.
the reduction in the amount of leave to 12 weeks and the expansion of coverage to companies under 50 employees, that doesn't start until January 1 of 22. Is that
That's
correct?
correct.
Okay.
That's correct.
All right. I think I want to be respectful of time, keep us on schedule here. We've
Mhm.
come to the end of the allotted time. We're going to go through the questions that we may have missed, and if there are any. I know you've had some of your staff actively online. I can see responding to some of the questions. Really
Yeah.
appreciate you've got your folks doing a good job there. That's
We're
very
a good
much
team.
appreciated. So. Can't give you some loud applause, but because we can't hear it from everyone. But I will say thank you very
Right.
much, and a hearty round of applause for you. Good job,
Thank
and
you.
suggest people to follow up with you. I've submitted a question on the online request, and you're very responsive. Got back to me relatively quick, so keep
Yeah,
that
we
up and
try.
encourage employers to do so as well. Thank
We
you,
will.
Andrea Barton Reeves.
Thank you. We appreciate the time. Appreciate it. Bye.
Okay, take care.